name is Valentino Free. The details now. With about 24 hours for Speaker of Parliament Alban Sumana Kingsford Bagbin to deliver his decision on the fate of 4 sitting members of Parliament who've switched allegiance from the parties they represent in the House, former Speaker of the House, Professor Michael Oquaye, has waded into that conversation, tackling the minority caucus's process to get the said MPs to vacate Parliament. The National Democratic Congress members of Parliament, led by their leader, Dr. Kezela Toba Forsing, are demanding that the NPP MPs for Suhum Kojo Asante and Agona West, Cynthia Mamle Morrison, and the NDC MP for Amemfi Central, Peter Yaw-Kwachiaka, who are contesting the 2024 parliamentary elections as independent candidates. An independent member of parliament for Formena, Andrew Amakwesiama, who is now contesting on the ticket of the NPP as their candidate, vacate their seats as stated in their respective party constitutions, and Article 97(1)(g) of the Constitution, which stipulates that, quote, an MP must vacate their seat if they abandon the political party under which they were elected, or if they opt to remain in parliament as an independent candidate, unquote. Listen to the argument on the floor of Parliament yesterday, despite a pending injunction application filed at the Supreme Court by Majority Leader Alexander Kwame Apenyomaken to stop Parliament and Speaker from discussing the issue as well as ruling on the matter. Here, excerpts of what transpired on the floor yesterday.
The then Speaker of Parliament, Right Honourable Michael Oquaye, upheld the NPP's position and took an action to enforce Article 97(1)(g) of the Constitution and ruled that the NPP Member of Parliament for Formena then had vacated his seat by his decision and conduct and hence ceased to be a sitting Member of Parliament. Mr. Speaker, this ruling was not contested and has still not been contested and remain good and valid as a rule of this House. Right Honourable Speaker, we therefore call on you to enforce the existing ruling of this House based on Article 97(1)(g) and (h). That decision, Mr. Speaker, applies to all 4 ex-members of Parliament.
Mr. Speaker, his argument is a political party wrote that its member has vacated his seat, and on the basis of that, an action was taken. That set of facts are completely different from what he's trying to force on us. There is no such petition from any political party, be it his own political party or our political party. So I just want him to understand that that argument has no leg to stand on. It falls flat. It sits on stilts.
The actions referred to by the minority leader have actually taken place. Is it true that these members elected into this House on the ticket of the 2 major political parties have suddenly decided that they are going independent? Now, the minority leader referred to 4 persons or 4 members of Parliament who have taken steps contrary to the Constitution. The majority leader in his delivery has not denied that that has happened.
Mr. Speaker, all those who have spoken so far have not disputed these facts. They have not disputed these facts. And in fact, the Electoral Commission, I believe, has issued notice of polls. And these facts have become public. So, the issue is the minority leader, who I believe by this time should properly be addressed as the majority leader, is seeking to bring to your attention these facts as matters of urgent public importance. The question is it a matter of urgent public importance?
So, right, Mr. Speaker, on the strength of the plaint before the Supreme Court and the injunction, whatever minority leader is trying to do via my vulnerable friend, the former minority leader, has been checkmated. Look, it has been checkmated by the application for injunction. I didn't tell you about the full implications of MOFAT, that when an application is pending before a court and you go contrary to the purpose and the intent of that application, you are in contempt. So I don't know why you are so excited about the fact that
So that's the member of parliament for Oquaye South, Samuel Atachia. Earlier, you heard Dr. Dominic Ayeni and also the majority leader Alexander Kwamena Apenyo Marking. Then opening that conversation was Dr. Kesa Latoba Forson, the minority leader. After that comment to the minority leader's statement on the floor, Speaker Alban Bagbin subsequently announced that he would deliver his ruling within 2 days.
Me, not Alban Sumana Kingsford Bagbin, but Speaker of Parliament. That office, not me in person. So he's taking that to the Supreme Court. I also listened to the comments on the proper view. Those of you who commented talking about the High Court and the determination of these matters. They are disagreeing with his procedure of going to the Supreme Court. But the reliefs are quite different from what he said, what he told me, because I have not been served with the process yet. And so that is still not before me. So please kindly give me these 2 days and I'll come here with a well-written ruling. I will submit it to all of you so that at the end of the day, justice would have not only been done, but would have been seen to be manifestly done in this matter. Yes, please.
So that's the Speaker of Parliament, Alban Sumana Kingsford Bagbin there. Ghanaians are waiting with bated breath, some fingers crossed, to that ruling of the Speaker tomorrow when the House commences sitting. And the Class News will bring you up to the minute updates on that ruling whenever that happens. Let's now listen to the former Speaker of Parliament, Professor Oquaye, whose ruling on the matter relating to the former member of Parliament in 2020 has become the yardstick for the minority's current demands. He spoke in an interview with Accra-based Joy News.
It's wrong because the benefit is not his. The law does not stand to his annulment. That's why I talk about husband and wife. Is it you who should say there's a problem in my house? You say there's a problem, I have a problem with my wife. And I'm saying I have no problem with my wife. What are you talking about? Because see, problems can arise in political parties. But they can talk and they can resolve them. It's not everything that comes within the political party that comes out. There may be trouble somewhere. We can talk about it. So it is the MPP that can trigger the removal of these, the removal of their own MP. Yes. So for to put it in proper context, if I want to do so, want something done, you can only do so as it relates to the only NDC member who is also, express his desire. That is so. To contest an independent. That is so. But he cannot force the Speaker to declare the seats belonging to the MPP MPs vacant. This can only be triggered by the MPP as a political party. By the MPP. And that's why I've given you the background of that legal provision. It is to correct a certain mischief that can be operated against political parties. It's not a matter of debate at all on the floor of the House. In fact, if you bring debate, you create a big problem. Because now you can always use a majority in Parliament to provoke a debate, and then they will start sacking the minority people. Is that not so? Yes. Because if you bring it as a debate and as a vote, then if you say aye and the ayes are more than the nay, then the motion has been carried and that person must be sacked from Parliament. What are you talking about? If he leaves his party, if he has been sacked by his party, if the party starts any disciplinary action against him, it's the party who knows. It's the party. For now, there is no evidence to suggest that the MPP has sacked them. There is no evidence that the MPP have sacked them. And it's the MPP who can say they have sacked them. There can be trouble. I've said it. There can be difficulties. But while those difficulties are going on, you cannot bring this kind of application to the court. And that is why the Speaker will pronounce on it by going through the processes of law that he should know. That is, giving whoever is being accused hearing and then pronouncing upon his exit.
So that's the former Speaker of Parliament, Professor Oquaye, in that interview with Joy News there. Let's go to the phone line and speak to the Member of Parliament for Tamale Central, Mutala Mohammed. Good evening to you, Honorable. Very grateful for your time tonight on 505. So, from the person who laid that foundation for the minority NDC in Parliament to stand on, he says that the process is wrong. It is not in the hands or locus of the NDC to trigger that, but rather the party these people belong to.
Well, good evening to your cherished listeners. But let me first and foremost state that the NDC is not standing on only the ruling of Professor Oquaye as a basis for which we are demanding the sacking of these 4 members of Parliament from Parliament. That is not, is one of the bases on which the NDC is making the claim they are making. Having listened to Professor Oquaye, I feel embarrassed and ashamed to be a Ghanaian. And I'll tell you why. I feel embarrassed and ashamed to be a Ghanaian and a member of Parliament. This was a former Speaker of Parliament and a lawyer of long years of standing. Now, so let's look at his analogy first and foremost. Because the MPP has not communicated the action of these members of Parliament to the Speaker, they cannot be deemed to be, representing the MPP as a legitimate members of Parliament. Where is that logic coming from? So it's like there's a rapist, may God forbid, in your house. A gentleman in your house has raped a little girl. Everybody has heard of the rape. And then the chief says that if the landlord has not reported to me, I can't take any action. I'm resisting the temptation to use certain words. That is the logic. Someone has raped a little girl or defiled a little girl in the open, publicly, or even at the market center. Everybody has seen. And then the chief says that because the landlord of the rapist has not reported to me, I'm not going to take any action. What logic is this?
Or because the family of the young girl who has been raped has not reported.
Have not reported to me. What logic is this? It's a public information. They have filed to contest as independent members of Parliament, and filing which was done by the Electoral Commission and subsequently published. What is he talking about? Go and read the NPP's own manifesto
or party constitution.
Sorry, party constitution. It is very clear. If you contest as an independent candidate against a candidate of the NPP, you are deemed to be sacked from the party.
They say automatic forfeiture of membership.
Yes. Of membership, automatic. So where is that logic coming from? And this is a former Speaker of Parliament. So shameful that he makes the statement he makes. Where have principles gone to? Where have principles gone to?
But yesterday...
At his, please, at his age, at that age, put aside the fact that he's even a former Speaker. At that age, he will stoop so low because of political expediency. What is he talking about? Why is it that when we are contesting, we are filing to contest as members of Parliament? The filing fee is paid by our respective political parties, not we the candidates. That's what happens. Do you know all the 275 members of Parliament, we didn't pay the filing fees. Our respective political parties paid for. So we are in Parliament for and on behalf of the parties we represent. Now, look at even the former Speaker. Sorry, the second Deputy Speaker. On whose action he came with the ruling he had when he was Speaker. And he has summated it 360 degrees. I feel ashamed, to be very honest.
The same position that was espoused by Professor Aaron Oquaye was yesterday espoused by the former second Deputy Speaker of Parliament, Member of Parliament for Isikado Ketan. He's also a lawyer, Honorable Jogate, that these MPP MPs are still, that's Suhum and Aguna West, are still members of the party. They have not resigned from the party.
So the
and the majority leader also said
MPP has 2 parliamentary candidates in those constituencies for this election. Is that what he's telling us? You see, the MPP colleagues are behaving like zombies. Zombie no go chop and let him papa tell them to chop.
Oh, who is directing them to do that?
It's their party. It's perhaps the president.
Oh.
Who is more confused than their members of parliament? Does it even make sense? Does it make sense? So is the MPP having 2 candidates in those constituencies as candidates for the parliamentary elections? Is that what they are telling us? Is that what they are telling us? You listened to Atachan yesterday. He threw law to dogs and he was being emotional and insulting everybody.
He said the minority want the speaker to go on a tangent that could cite him for contempt of court because the case is already in court and all that.
Look,
and
first
speaker
and foremost,
is not going to give any ruling
no
on
court
that.
in Ghana, no court, and I say this with emphasis, no court in Ghana can determine to Parliament how Parliament discharges their responsibilities. No court. Parliament is an important arm of government, just like the judiciary and the executive. What the court can do is to have a determination on a decision taken by Parliament, but they can't determine to Parliament how Parliament works. So the attempt to even injunct Parliament is bogus. How do you injunct Parliament? To stop Parliament from performing its function, its legislative role? No court in Ghana can do that. What the Supreme Court can do is if Parliament takes an action or makes a decision on a matter, the Supreme Court then has the mandate to interpret the legality or otherwise of the decision taken by Parliament. But no court can determine to Parliament how Parliament discharges its functions and its responsibilities. I mean, when I listen to some of these lawyers, I am tempted to say that it was a good decision after getting my LLB not to go to the law school. Seriously.
A member of your own party, former member of parliament for Kumbung, Ras Mubarak, says that the NDC's decision.
I'm not going to be responding. I'm not going to be responding. I'm not going to be responding to Ras Mubarak. I respond to him in his capacity as who. I'm not going to respond to him. I'm not going to, and I won't be tempted to responding to him. That's his opinion. He's entitled to holding that opinion. But one thing I can say is that I'm not making a statement that is anchored on emotions. I'm talking about the law. So I'm not going to be responding to whatever Ras Mubarak or whoever might have said. Everybody has an opinion, and opinions are like noses. They don't come with one shape. Anybody can have an opinion on any matter.
Now, we are to expect 2 rulings. Okay, either of these 2 is going to happen tomorrow when the speaker takes the chair. The
speaker should have ruled on this matter yesterday. There is a precedent. Look, Parliament, business in Parliament is guided by 3 very important things. 1, the Constitution. 2, the standing orders of Parliament. And 3, decisions or precedents of previous speakers. So I don't know why the speaker even didn't give his ruling on this matter.
He says he will bring a written ruling tomorrow. So 2 things.
This one, I agree, and I respect that.
It's either he upholds the minority's position or decides otherwise against it.
Well,
either of the 2. Whatever happens.
I can't foresee the speaker, not upholding the minority decision. I mean, if he followed the debate on the floor yesterday, it was very clear that whereas the NDC members who were debating on facts, the MPP members were debating on nothing except emotions.
They were contributing to the statement with emotions.
Yes, it was anchored by emotions and nothing else. But it was only Honorable Joe Gatti who attempted to even use debate on the issues of the facts, even though his debate was also wobbling. He was the only person. That day, Atachan came, and I was wondering what kind of law some of us have learned in this country.
Again, if it doesn't go in your favor, what will the NDC minority do?
Well, when we get to the bridge, we'll cross.
we'll have to just keep our fingers crossed. 24 hours is just around the corner. Honorable, very grateful that you joined us. That's the Member of Parliament for Tamale Central, Mohamed Mutala. There. Let's stay on the line a while longer and speak to Executive Director of Parliamentary Network for Africa, Sami Obeng. Mr. Obeng, grateful for your time tonight on 505. Quite an interesting development, isn't it?
My pleasure. Yes, it is interesting. And we look forward to what the eventual verdict will be, bearing in mind that whatever decision gets taken would have far-reaching consequences on Parliament and how members of Parliament would have their seats declared vacant or otherwise going forward.
To that minority caucus who are hoping to be the majority by close of business tomorrow, it's a one-way decision. Just like Honorable Mutala said, that he doesn't see the Speaker departing from the path that has already been charted. And the law is very clear. Per the NPP constitution, if you go as independent candidate, if you're sitting MP, you have automatically forfeited, or even if you're a member of the party and you lose primaries and you decide to go as independent, you've automatically forfeited your membership of the party. So these two sitting members of Parliament, Aguna West and Suhum, have automatically forfeited their membership immediately they filed. And then for an independent member of Parliament to go and contest on the ticket of a political party, the law, the constitution, standing orders is also very clear. So they don't see the Speaker departing from that. All the Speaker would have to do is to declare those seats vacant, including the NDC's Amenfi Central. Do you see anything different from what the minority is looking at?
Well, I do not think that Speaker Bagbin should be given his ruling based on what minority is looking at or what majority is looking for. It should be based on holding fidelity to the constitution of our country, bearing in mind that this is going to be a further precedent that will, at least every 4 years, come up again. And he would either be referenced as a speaker who did a good job or a speaker who did a bad job. Now, you have clearly distinguished between the two situations we have. The one involving an independent member of Parliament who came to Parliament as an independent member and is seeking to join a political party by virtue of his declaration to be contesting the name of the NDC. Now, the Constitution in Article 97(1)(h) was clear about that. And so I think that that may be the lowest hanging fruit in this circle. But in the case of the members of Parliament who have expressed interest to stay in the next Parliament as independent members of Parliament, but have not said anywhere, and their parties, by the way, have also not said anywhere or officially communicated that they have relinquished their membership in those political parties. I think that we must be careful in determining at what point one chooses to be a member of a political party. Let me cite an example. A few months ago, there was a by-election in Komeru. A sitting or a former member of Parliament for the NDC in that constituency, who was a member of the party still, if my memory serves me right, contested as an independent candidate in that election. Now, in that election, he lost. But of course, in the public domain, the conversation was about whether he had relinquished his membership of the party and what have you. We know fast forward what has happened in that case, where the party itself accepted to reconcile with the gentleman, membership in the party regularized or not taken after all. And this is where we need to distinguish between the Oquaye case of 2020 and the current case. In the case of 2020, 2020, there was a political party who came out clear and wrote to the Speaker and said, we do not recognize this gentleman any longer as our member. Yes, our constitution says this, but for the avoidance of doubt, we are coming to state it clearly in writing that this is the status of the Honorable Member of Parliament, for which reason Article 97(1)G should apply. I find it difficult that the Parliament of Ghana should, in this current instance, be taking a decision based on what is considered to be the situation from the public domain, rather than a formal communication from the political parties involved, in this case the NDC and the NDC. Especially when we've seen signals from at least the majority leader's presentation on the floor of Parliament yesterday, that so far as is concerned, his two colleagues are still members of their party. They've not been sent out of the party. They've not indicated any reason why they do not want to belong to the caucus in Parliament and what have you. All I'm saying is that we must not consider the current situation as completely equivalent to the case that Speaker Oquaye ruled on. Some of us have maintained that even then, Speaker Oquaye's general disposition on the matter, to the effect that once somebody has indicated he wants to go or contest in the next elections as an independent, it means automatically Article 97(1)G applies. I am of the opinion that Article 91(7)G talks about somebody who came to Parliament as a member of a political party, but is seeking to stay in that same Parliament, not the next Parliament, as an independent member of Parliament.
So we just have to wait a little while longer for the Speaker's ruling. I'm sure tomorrow, when the Speaker gives that ruling, we'll come back to the aftermath and all the discussions.